Right, ladies and gentlemen, if you would like to please go back to your seats, fasten your seatbelt. We are approaching the final destination, and we are now going into our third and last panel of the day. I'm going to very briefly introduce our moderator. I'm having the pleasure to introduce for two reasons. One, because she did the wrong thing because she studied at Paris 2, but now she has bridged, so she's slowly bridging the gap. She's moving over to Paris 1, and she shows that it's not because you started the wrong way that you can't go to the right one. So Yas is teaching international law at Paris 1, and the second particular point I'd like to highlight is that Yas is from my hometown, and that creates lots of links. So, but just to thank her for being a partner to this conference, being part of the sponsors and the supporters, for being here, and for moderating this third session. Yas is a partner at Sherman and Sterling, the International Arbitration Group, and she leads the public international law practice of the firm. And in this capacity, she's acted as counsel, as arbitrator, and what we have to do now is convince her that maybe there's also another way, another approach. So you have the floor, Yas, and thank you very much.
Thank you, Anna. Good afternoon, everyone. Very briefly, I would like to join everyone in thanking Susan, I don't know what she is, Susan and Anna for such a formidable and well-organized conference. Frankly, I'm very impressed. And I'm impressed by the format, which is quite unique, I have to say. I would also like to thank the great discussions we have so far, and I will try to initiate some more this afternoon. I would like to thank Professor Wiesman for his brilliant presentation earlier, inspiring, I have to say, and I will refer to it very briefly. So just a few thoughts before we start the panel. I would like to expand on my experience as counsel, acting for both investors and states. And sometimes I sort of heard concerns, and certainly there is a concern when we discuss these issues, talking about arbitration, that we don't throw out the baby with the bathwater. So it's important to keep in mind the progress that has been made and what we've achieved in developing something that's totally unique in terms of access to neutral, independent justice for investors. First observation, when I act for investors, you should not overlook the fact that going to arbitration, initiating an arbitration against the host states is always a very difficult choice and a difficult decision to make. It's not made lightly because it means costs, it means a long time, it means undermining a relation and often a long-time relation with the host states. So it's never done lightly, and investors go to arbitration having really sought other ways of resolving the dispute. And we heard earlier that sometimes in the figures that we heard from Professor Wiesman and from Ignacio that there may be settlement before the initiation or after the initiation of the arbitration, and that certainly is my experience. When investors start an arbitration, if there is a prospect to resolve and to amicably settle the dispute, they welcome it. The point that was made by Mark Feldman earlier is that for that you need both parties to agree on and have to will to go forward with the negotiation and a settlement. So in that sense, initiating an arbitration and the prospect of the arbitration may create leverage, and in my experience, when you have that prospect, it sort of is more conducive to a settlement than when you don't, and when you have something which is softer and more less compulsory. The second point I wanted to make, I don't think we've discussed it much today, but it was definitely something that I read in the blog postings, and that is the point of reciprocity. And what Professor Shin, I think he's around, yes, I can see, refers to as the mutuality of interests. What is interesting is that for states, when they negotiate treaties, investment treaties, those benefits that they question in relation to inward investment is exactly what they look for their own investors when they talk about outward investment. So the reciprocity is hugely important here because you want to give the protection framework to your own investors, and this is something that we have witnessed. And the postings by Laurence Boulle in South Africa, by Professor Shimon Korea, and by Pedro Braga relating to Brazil are quite telling in that respect. And if you look at the Chinese evolution with the initiation of arbitration procedures by Chinese investors against host states, that is also telling of the fact that reciprocity is very important in the negotiation of treaties. And in terms of the protection that you want to be integrated in those treaties. Last point, and here I would like to refer back to Mahnouch's question, which is a very important one. What are we talking about? For the way forward, if Anna wants to go back to answer to a number of suggestions, or Meg back to Exit, or Elise back to Exit with suggestions about what to do, and this is the subject of our panel for the way forward, we need to agree on the premises. And I'm not sure that we agree on the premises of what alternative dispute resolution means. Are we talking about dispute prevention, or are we talking about a set of tools that are compulsory? Are we talking about a set of rules that are out there already that you can use? And international law definitely offers mediation and conciliation negotiation perspectives. This is not something you need to integrate. They already exist out there and you can use them. But do you want to use them in a compulsory manner, or do you want to have the flexibility? So, and again, in my experience, flexibility is very important because depending on the case and on the investor's need and the host state's needs and desires, it can be something that achieves more easily a settlement. With that, I have other points that I will not make because I want to keep the timing. So with that, I will just pass on the floor to Cathy Costantino, who's going to make a broad, and again, just for the sake of time, I will not give you the impressive biographies of everyone on this panel, so I will refer you back to the biographies. Cathy's going to give you an overbroad picture of the way forward, and she will be followed by Wolf from Kumberg and by Laurence Boulle on mediation issues. And finally, we'll hear from Jose Antonio Rivas, who will, I think, give us both his perspective as counsel and as a state representative in negotiating treaties. And finally, Noriyuki Mita, who will give us the perspective of Japan. And Professor Mariana Hernandez will give you a comments at the end. I will keep it open to ask questions in the middle between our panelists. So let me know if you have questions. Thank you.
Thank you. Let me start off by saying it's an absolute pleasure to be here. I also want to thank a group of stakeholders today who I don't think we've thanked yet. And those are the students who helped put this together, the liaisons, those people who helped us along the way. So a bow, a thank you, and a shout out to the students who I think just did a terrific job today. Let me start out. I was struck this morning about beginnings and endings, and I'm standing up because I think better standing up. It gets the energy flowing for me. I was thinking this morning about beginnings and endings, and for some reason T.S. Eliot came to mind, and the four quartets. And if you know anything about T.S. Eliot and the four quartets, in the first quartet there is actually a quote where he says, "The way upward and the way downward are the same." Quartet 2, "Home is where we start from." Quartet 3, "What we call the beginning is often the end, and to make an end is to make a beginning." And Quartet 4, this is the one that I think is the most important for you, "We shall not cease from exploration, and the end of all our exploring will be to arrive where we started and to know the place for the first time." My encouragement to you today, from a design perspective, is the invitation to explore. There are a lot of terrific ideas in this room, and I really want to encourage you to explore today, and as we leave today, I want to encourage you to know the place for the first time. I want to encourage you to look at dispute resolution in your field with fresh eyes, with beginner's mind. I want to invite you to examine what you are doing, why you are doing it, and how you are doing it. I am going to take a really helicopter view here. And as my husband told me years ago, Cathy, the invitation to dance is the invitation to decline. So if you decide to look at the design and decide you don't want to use mediation or you don't want to use facilitation, that's acceptable, but I think you should at least look. And I think you should at least consider, and I think that you should do it in a way that is inclusive and that really looks at all the possibilities. How many people in the room are investors? Yeah, let the record reflect there's one hand in the room of investors. So I would suggest to you that from a design perspective, you might be missing some stakeholders. You know, they have the bucks, they have the money, and they're relatively important. So my encouragement to you, when you do this process, is to make sure that you include all the stakeholders. I'm actually pretty visual, so I drew you a picture. Here's my picture. And it occurred to me that the topic for this panel is creating options for the future, setting a common agenda of mutual interests and expectations. What you're talking about is present state. It's where you are. This conference is about where you want to be, desired state. In order to get there, you have posited that you have to think about common agenda, mutual interests, and expectations. And the way to get from here to here is through some kind of a design process, some kind of a dispute systems design process, which is what I'm here to talk to you about today. I think that there's a couple things going on in the world today. One is the investment world is changing. I work at the Federal Deposit Insurance Corporation. I've done banking law now for 24 years. I've opened bank, closed banks, sold banks, liquidated banks. I've done a whole lot of things to and with banks. And I know that the banking world is changing and the financial world is changing. We have a lot of global connection. We have a lot of people in places where they're using different financial instruments. They have different interests. The state players are changing. We have small countries, we have large countries, we have developing countries, we have countries who use civil law, common law. The world is changing. And let me say that third, the lens is changing for what you do. Not everyone sees investment disputes from a legal perspective. Some people see them from an international law perspective. Some people see them from a monetary perspective. And so I think it's important that we really keep in mind, many of us in this room are lawyers, and we really shouldn't allow that to be held against us. We are what we are. But there are other people out there who think about this very differently. And they think about it as transaction, or they think about it as public law, or they think about it as international law. The other thing I would say is that in my experience, I've been a mediator, I've been mediated, I have been an attorney representing clients in mediations. I don't necessarily think that mediation is that arbitration is necessarily easier. I think mediation can be quite difficult. I think the problem with transparency that we talked about this morning, you can design around that. We can figure out how to do that. You're all smart people. We can figure out how to deal with the issue of transparency if that's what we need. If that's what your design process shows, we can figure out a way to do that. Governments mediate all the time. The federal government, the U.S. federal government mediates lots of stuff. There's an ADR Act. We can figure out how to do this. It's not difficult. It's really not. We've got the best and brightest minds in the room. We can do this. I will tell you that banks and financial institutions use ADR. They use it all the time. They use arbitration, they use mediation, they use mini-trials, they use early neutral evaluation. They do it. I work with countries. I will tell you that countries do this all the time. Countries mediate, countries facilitate, countries do early neutral evaluations. So this is not anything that's new or different. The last thing I will say before I go into my slides, I teach systems design at Georgetown Law School. I actually taught yesterday until 3:30 and then hopped in my car and drove down here after teaching 2 days for 10 hours at a pop. And one of the things that we did yesterday, which was interesting, is we looked at online dispute resolution. We had Ken Feinberg talk to us in the afternoon about pay-czardom. And on Sunday morning, we went to Africa and looked at a mediation in a small village from a virtual perspective. Those are 3 very different types of systems design, but they're all possible, and they're all probable, and they're all doable in today's world. There are digital natives, there are digital immigrants, and then there are digital dinosaurs. I do not want the people in this room to be dinosaurs. I want you to be on the forefront of dispute resolution and conflict management systems design. I don't want you left behind. All right? And I will tell you that in many industries in the world, they're doing dispute resolution, and they're using systems design. Might not be mediation, but they're being very creative and very innovative. I will tell you that countries are doing this. I don't want you to be left behind. I don't want you to not be part of what is really becoming the use of some additional tools that have proven to be quite effective. Let's take a minute. The purpose of the presentation today, I want to identify some conflict management systems design principles, and I want to talk a little bit about the effect of culture. And by culture, I mean fairly broad-based systems design. Let me spend just 1 minute because I think we need to get our taxonomy and our jargon correct. All right? Disputes and conflicts are two different things in my view, and I've written a fair amount about this. A dispute is actually something that has escalated into a product of a conflict. I can have a conflict with you, I like coffee and you like tea, but we don't have a dispute. When I tell you that you can never drink coffee for the rest of your life or never drink tea, we probably have a revolution, particularly if it's early in the morning. But the point is that I think you would do well to make a distinction between disputes and conflicts, because disputes get resolved and conflicts get managed. And not everything that you deal with has to be resolved. Some of it can be managed. I'm beginning to have a theory in my brain that there are actually some things out there called misunderstandings. And they're not conflicts and they're not disputes, they're just misunderstandings. And misunderstandings allow you the possibility to engage in prevention and de-escalation. Those are the two pieces of the dispute resolution pie that I think you're light on. I think you're light on prevention. I think you're light on de-escalation. When I look at you as an industry, when I look at you as a model for resolving disputes, and I've looked at a lot of different industries, and I've looked at a lot of different countries along the way. We're going to learn to go in the right direction someday. Okay. Approaches to resolving disputes is pretty basic. You can either reconcile disputes, adjudicate rights, or use power. Most of what I have heard and most of what I have read, and I have been following the blogs and reading what you're all doing, most of what you're doing is rights-based, and that's absolutely fine. I don't want there to be any perception out there that rights-based isn't good. It's fine, but it may not be enough. I think of rights-based, if you play baseball at all, it's the backstop when the catcher misses, all right? You can't prevent it, you can't de-escalate it, you can't use an interest-based process. The rights-based process is the backstop. And it's what allows you to know that you're going to get closure and that you're going to get done. So I would encourage you to think about kind of moving your taxonomy up and starting to think about some interest-based processes. I'm going to discourage you from moving your taxonomy down. I'm going to discourage you from doing things like wars and violence and strikes and the more power-based methods. And I'm going to encourage you to think about moving in the other direction. There are 6 stages to conflict management systems design. Notice that I don't call it dispute resolution systems design. I call it conflict management, so it's the whole spectrum. Prevention, de-escalation, resolution, and management. Entry and contracting, it's how you get in. You have an opportunity now, because you're having this conversation, to think about how you want to do your systems design. You can do it at the front end. You can do it by contract. You can do it through terms of reference. You can do it through treaties. Lots of different ways to enter and contract. The assessment, you ought to be thinking about what the types of disputes are. Are they contractual? Are they rights-based? Are they transactional? Are they relational? That will define your taxonomy. In terms of goals and evaluation, I would like to see you have a little bit more empirical data about what's working, what's not working, and why. I think there's a ripe opportunity here for you to begin to study yourselves and study what you're doing. Training and education, we talked a little bit about this morning. We talked about the need for capacity building. People will not choose that which they do not know. Implementation and feedback as well. Lots of possibilities here. I'm not going to encourage you to start on the transformative end of the spectrum and do what I call transformative mediation. Not going to encourage you to do a lot of therapeutic stuff. Instead, I'm going to start from where you are. You're at arbitration, and I'm going to encourage you to start to step this way. I'm not going to start you all the way over here with the highly interest-based models and move this direction. I'm going to have you start from where you are. You're all comfortable with arbitration. What that means is maybe you want to talk about Mead-Arb. Maybe you want to talk about Arb-Mead. Maybe you want to talk about mini-trials. Maybe you want to talk about early neutral evaluation. I am not trying to sell you on the M word. I'm suggesting to you that there are possibilities other than the M word, and I'm encouraging you to think about those and to keep your mind open. With regard to the critical elements and the components of systems design, I believe that Professor Schneider talked to you about this a little bit before. Unfortunately, I wasn't here. I was on a phone call with a federal district court judge doing an oral argument on whether or not we needed to produce our ombudsman to testify. And the good news is I won. We are not producing them. She was not compelled to testify, so ADR has been protected for yet another day. But I did not hear her presentation. I know that she used some of my concepts. She really talked about the substance going forward. I want to talk about the process. You need to figure out, with regard to participation, who should be involved in this design process to move you forward. You need to figure out how you're going to do it. You're going to have a convention, a convening, a working group. What are you going to do after today? You need to think about suitability, and Frank Sander would say you need to fit the forum to the fuss. Maybe arbitration doesn't work all the time, but some of the time. Maybe meet-arb works some of the time, but all the time. You're going to start to put the pieces together. You're all bright. You can do this. Permeability. How does it seep down? How does it become part of the system? How does it spread out so it becomes a way of doing business? Not just a conflict management tool that you've added on or slapped on the top. And then your accountability. I want to point out we need accountability for two things. You need accountability for the process and the results. Those are two separate design problems. They're two separate design issues, and I would encourage you to think about it that way. I have 1 minute left. So, cultural implications, I think, are pretty straightforward. You need to think about who the players are, what the disputes are, where you do this. The place and symbolism matters. When you do it, timing, how you do it, tone, pace, and all those things that go into resolving disputes and managing conflicts. In closing, let me say that people are going to watch you. And as you engage in this design process to figure out where you want to go, I would encourage you to walk the walk. If you are going to start to impose things, and one of the things you're going to impose is mediation, you're not going to get a lot of buy-in. You're not going to get a lot of ownership. You want to watch for power, rank, and privilege issues. Watch for those who aren't at the table. Perhaps the NGOs aren't there. Perhaps there are indigenous people who aren't there. You need to really keep in mind who's not in the room. From an art perspective, I call it thinking about the negative space. I want you to anticipate resistance and plan for patience. People aren't just going to start to do new stuff overnight. You're going to get pushback. Honor self-determination. Some people may not want to use mediation or interest-based processes. That's okay. And remember that if you decide to design something, some people may say no, and that's okay. My charge to you in closing, I would make 3 charges to you. One is, do the work. Do the work. It's going to take some work. Do the work. My second charge to you is have the conversation. Have the difficult conversations about what's going to work and what's not going to work. And my third charge to you is to look for the possible. Look for the opportunity. This is an opportunity for all of you. I would invite you to take hold of it. I will do whatever I can to help you. It's been a pleasure to be here today. Thank you.
Thank you, Cathy. Do we have any questions at this point? And before we move on to the topic of mediation, it might be a good start. I have a question by Professor Bingham who goes back to the issue of the uses of the term ADR and how it fits with substantive law. Cathy, do you want to expand on that a bit? And you talked about rights-based, and at the end you said, mentioned the fact of imposing something to the parties. How do you view this process? Do you view this as imposing in the treaties a number of mechanisms to the parties? Do you propose something else? What do you propose about?
Well, what I would encourage you to do, and it's only an encouragement because I can't tell you what to do, I have a model based on 4 quadrants, and my third quadrant is what's called interest-based design. And I would encourage you really to get some stakeholders in the room and think about this. And you may decide that part of your design is going to be rights-based and substantive law-based, and that that's necessary. The professor talked about that this morning, and I don't have any problem at all with having a rights-based substantive law backup. How you get there matters to me. And I think that imposing it is probably not the most sustainable way to do it. but I am not in any way saying that you shouldn't have rights-based backups. I'm just suggesting that you might want to have other choices other than simply rights-based backup. Substantive law goes to the question of whether you need precedent. Not every dispute needs precedent. I mean, let's be honest. Some disputes are just disputes. People just want to get done and move on and get their money or not get their money. And so not everything has to have precedential value.
What about the fact that the treaties open rights to the investors, and it's the rights that are being enforced?
Yeah.
It's not about money. It
Absolutely.
can be about money, but it can be about specific performance, as Professor Rivas said.
And you are in a different design milieu than many industries are in because you do have treaties that set up the paradigm and they set up the taxonomy. And so, one of two things has to happen. Obviously, treaties are very difficult to change, and I'm not suggesting you do that. But I'm also suggesting that some of the language this morning, that there's already some models to allow for conciliation and mediation along the way. And that you look at where the possible openings are. I'm not suggesting that you override treaties or do that which you cannot do by law. I'm a lawyer and I have respect for it. But I'm suggesting that you look at where the openings might be along the way.
More questions for Cathy at this point? Yes, Roberto?
A very quick one. Excuse my ignorance, but if I had a quick question, when does a conflict become a dispute?
It's a great question. When does a conflict become a dispute? I think a conflict becomes a dispute when people are unhappy enough to begin to take an action to resolve it. All right? Frequently, a conflict will become a dispute when it goes formal. I used to say goes postal, but the Postal Service doesn't like to do that. So now I say goes formal. When a dispute goes formal, when somebody files something, when somebody thinks a right has been violated, and quite honestly, it's a little bit like, I think you know it when you see it. I think most people know when a conflict is morphed into a dispute. It's when you move from dissatisfaction that's intangible to a mismatch that's very tangible, and it's the product of the process of the conflict. If you ever raised kids, I'll tell you, you know when a conflict becomes a dispute. They let you know that, and I think that for most of what you do, you all know when it's a dispute. You all know when it's risen to the level of having to be resolved, and it can't be tolerated anymore, it can't be managed, it may be contrary by treaty, it may be contrary by law. That's a dispute. That's a dispute.
More questions? We can come back to this later. Laurence? No, it's both actually. Sorry. Talking about mediation.
Well, thank you very much. Actually, that was a very interesting question that was asked before. How many investors are there in the room? And actually, Michael McElrath of GE and I think myself are the only people in the room that represent the investor community. And that's actually a telling statement because getting the investor community involved is, I think, essential, but also extremely difficult because the investor community has to see an interest, I think, in establishing perhaps a different method of dispute resolution than what they see in their contracts. And I think that's a challenge to this group to get them involved, but I think it's not impossible if you can demonstrate that there is an interest that is being addressed. And certainly people like Michael McElrath and myself are extremely keen on seeing something like that happen. I'm the assistant, or one of the assistant general counsels of Northrop Grumman Corporation. Northrop Grumman is a multinational aerospace company. And we operate in many different parts of the world, and we're involved in a lot of infrastructure projects. It's interesting, I actually was a litigator originally. I've now been in-house counsel for about 20 years. And to see the difference in approach and in analyzing the way conflicts are dealt with from the outside counsel perspective and the inside counsel perspective is quite different. And I can tell you that certainly over my 20 years as in-house counsel now, I've seen a sea change in the way that we deal with disputes. From the traditional means of state court litigation through arbitration, and now increasingly through the use of ADR. I mean, in corporations like ours, it has become an accepted part of our disputes process to look at ADR, and in particular to look at mediation as a way of dealing with our disputes. And in fact, every one of our disputes is analyzed to determine whether mediation might be appropriate for that particular dispute. And if there's one message that I can leave you with today, is that from my own perspective, mediation works. It really does work. And I've heard all the arguments before from many different people and from different industries that it just doesn't work in my backyard, maybe it does in yours. It's absolutely not true. I don't think there's any dispute that cannot be mediated. I'm not going to say that every dispute can be resolved and that a settlement will be reached, because that isn't true. But I can tell you that any kind of dispute can be mediated. And in fact, I think, and just listening to the arguments or some of the points expressed today, I mean, mediation is part of the process. It's not independent. It doesn't replace anything else. It's simply part of the process. I think you have to take a holistic view of this, as Bill was saying earlier as well. Business, and I think states and governments are no different in this perspective. I heard someone state earlier, taxpayers' money shouldn't be spent on fighting disputes. That's not the point. Just like companies and shareholders' money should not be spent on fighting disputes. You have to find ways to resolve those disputes. And the earlier you resolve those disputes, the better it is for all parties concerned. I mean, the point made about when does a conflict become a dispute is actually a very interesting one, and one that I've seen over the years being involved in industry. Conflict can be managed, it's absolutely true. But once that conflict escalates to a point where the parties are no longer communicating with each other, and that's the key here, there's a loss of communication, that's when it becomes a dispute. The parties can no longer manage it themselves. And it's at that point in time that you have to find a mechanism to allow the parties to open up the channels of communication again. Now, is that through providing the dispute to outside lawyers, which is traditionally what we've always done? Well, perhaps, because lawyers are trained to negotiate, and in a sense, that is the first avenue of trying to resolve the dispute. But lawyers, outside counsel, of course, are also retained by a party to represent the interests of that party. And at that point in time, they are then no longer objective in their views, and it becomes very difficult for them negotiating with one another to find a solution. So a third party, a neutral, and there are many different ways a neutral can be brought in to the dispute, is often extremely valuable to allow the parties to assess their positions from an objective position, but also to allow the parties to start to communicate again with each other. And whatever form of mediation or the structure that mediation takes, and there are many different forms, but the key there is that it bridges the gap between the parties. It allows them to start communicating with each other again. And I think that's one of the beauties of mediation. I heard earlier as well somebody saying, well, you've invested the time and effort and money in mediation, and if it doesn't work, then you're right back to where you were before. Well, that's absolutely not correct. What mediation allows parties to do is that they actually look at their case much earlier than they might have looked at it. There is preparation that's required, but that preparation has to be done somewhere along the line anyway. And so the earlier you prepare, the earlier you can also assess the strengths and weaknesses of your case. And even if the matter doesn't settle, that preparation time is something that is well invested in any event. And I can tell you from my own experience, and I'm talking about commercial situations, parties that do prepare early and do not perhaps settle after mediation will likely settle before they go to court or before they actually go to arbitration, simply because they understand the strengths and weaknesses of their case much better than the normal process where people don't prepare until they have to and before they get to trial or to the tribunal. So I think that's an important point to understand. The other important point is that, of course, the mediator is not a decision maker, but a facilitator. And so it's the parties that retain control of the process. And that can't be overemphasized. The parties are the ones that entered into the agreement to begin with. They had a relationship. That relationship broke down. The parties are actually the ones that are best placed to find a resolution to that disagreement or to that dispute. But they need somebody to help them to do that, and that's where the mediator, the facilitator, becomes so important. The beauty of mediation, this was expressed, I think, earlier already, is that it isn't bound by procedural structure. It's not bound by the requirements of arbitral rules. It's not bound by the requirements of state court procedure. It allows interests that aren't necessarily before the arbitrators to be explored. It allows, I think I heard earlier too, third parties that aren't actually stakeholders per se in the proceeding, but are stakeholders in the wider sense, to perhaps participate and have their views heard as well. It allows a wide range of means to resolve that particular dispute. The parties can explore all types of different avenues to find a resolution. That, of course, isn't true in the arbitral process itself. So the avenues and the opportunities that arise are very much actually like the opportunities when the parties first got together to explore a contractual relationship with each other. All of a sudden, those opportunities arise again. And you can come up with very novel ways of resolving the dispute, which just don't occur when you have arbitrators making a decision and imposing that decision on the parties. Even when it comes to settlement and it comes to actually enforcing the settlement, it's much easier to get parties to actually live by what they agreed if they themselves have come to that resolution. Much more difficult if somebody imposes a solution on you that you don't agree with, but you're then grudgingly forced to abide by that decision. Well, you're going to do everything possible to see that you don't have to comply. And so where you've got a mediated settlement, you're much more likely to have the parties actually comply with what was agreed. Perhaps looking at some of the other points that I think really bring a benefit through the mediation process itself. And I don't know how much you all know about mediation and the process, but the process is one that actually encourages the parties to start opening up to, first of all, the mediator, because that's where they start to communicate. They can't communicate with each other anymore, so they're communicating through the mediator, and the process allows the mediator to do that. To the point where the parties eventually, and in most cases that settle, start to sit across the table from each other again and start communicating directly with each other. And once that happens, that's when you have a breakthrough, and generally that does lead to a settlement. The other thing about the structure of mediation itself is that it's extremely flexible. So you can get the right mediator or co-mediators, and increasingly co-mediation, is being used. And I think in the forum that we're talking about, in fact, co-mediation has real advantages because, as somebody earlier said as well, particularly where states are involved, you want to ensure that the mediator is somebody that has the status that will be recognized by a state and by the state participants as having a certain gravitas. So you can very well have that kind of individual, for example, perhaps a retired ambassador, but then again, mediating with that individual somebody who perhaps has the subject matter expertise, or perhaps has more experience in a certain type of mediation, so that the two of them together then mediate the dispute. That's also extremely important, I think, from a cultural perspective, because you can get then people involved who perhaps are more understanding or knowledgeable about a particular culture. I just have a few minutes left here, and I made some notes here as I listened today, which perhaps I humbly can put forward as some suggestions as to how this particular forum could proceed. I think there has to be a structure of some sort that has to be put in place. You can't really do this on an ad hoc basis simply because of some of the concerns that were raised earlier, and so it has to be done within existing institutions, and so it has to be built into that process in some way. The mediators themselves have to be drawn from, I think, a panel that is qualified and recognized. Michael McElrath spoke about IMI. That's just one example where we're trying to put in place a system of qualified mediators worldwide that can be recognized as being qualified. It should be recognized that mediation does not replace arbitration, and nobody, I think, is saying it does. It's got to be part of the overall process. Perhaps including step clauses in some of the agreements that investors enter into with a state, so that it's already there in the agreements, so that nobody then has to be worried about the political repercussions of going to mediation. We have to ensure that persons with authority are there at the mediation. With companies, that's often not difficult because you know who can bind the company or who can't bind the company, but with states, of course, that is much more difficult. I think the Peruvian example that we heard earlier is probably a good way to start structuring that. And as I said before, co-mediation is something that should really be explored in the context of these types of disputes.
Just by way of follow-up, one question coming out of the bloc countries. There's a number of comments on what it is that investors want, and Susan is nicely quoted from Rolling Stones, can't always get what you want, you can't get what you need. And there's one particular posting where the person says that it's not always about what investors want, but what the lawyers want. So in your experience of mediation, and you mentioned involving the lawyers, is it what you want as the investor, potential investor, or are you induced by it?
I think that's a very good point that is made there, because parties in a dispute, so I'm talking about the commercial party here, often just turn the dispute over to the lawyers and allow the lawyers then to make the determinations for them. And I think that's where investors probably are at fault. I mean, you have to be involved as the commercial party in making a determination as to what the result is that you're trying to achieve. You can't just turn this over, of course, to the outside lawyers. Smaller companies probably don't have the expertise to be able to deal with that. Larger multinationals will have the internal expertise to actually set out the objectives that they're trying to achieve. But it's a good point, and you have to differentiate, I think, between what the lawyers, the outside lawyers perhaps, are saying that the party wants and what the party really wants.
In my experience, the more formal the mechanism is in mediation, conciliation, arbitration, the more lawyer intervention is requested by the parties. And with respect to negotiations, our clients sometimes ask our help in the negotiations, and sometimes we say, we're going to go ourselves, and it's fine. And we certainly respect that. So as regards mediation, how do you deal with that? Do you want your lawyers to be there?
Well, the lawyers play a very important part in mediation, particularly lawyers who've been trained in what mediation is. So they help to prepare the parties so that when you come to the mediation, it's much more effective because the parties already know what to expect. But the beauty of mediation, and particularly with skilled mediators, is that they will be able to draw from the parties themselves what it is they want. And they're going to get the parties very much involved during the mediation rather than the lawyers. And the lawyers will slowly take a backseat to the parties themselves, and the parties will become much more involved in what happens in the mediation.
Okay. Any questions for Wolf? Yes? Can you please say your name for the record?
Hannah Tumpel, ICC International Chamber of Commerce in Paris. I'm responsible for the dispute resolution services, so for everything that is not arbitration. I just wanted to reflect or comment on Wolf's talk from an institutional point of view, with just a couple of experiences or anecdotal evidence also possibly. Although all the parties filing mediation cases at ICC, and almost all those cases are very complex, often multi-party, very high amount of dispute, international cases, are always represented by counsel. But what we notice is that it is often the parties themselves which want to go forward with the mediation. Because the lawyers often tend to be specialized in arbitration, and they are very nervous that they aren't yet allowed to file a request for arbitration, or even if they are allowed, they are asked to stay the arbitration procedure for the time being in order to go forward with the mediation. So from what we see, that shows that it is even more important to go to the investors, to go to the corporations, and make sure that the in-house knowledge about different dispute resolution procedures is high within the corporations. Because I always see that there's a sort of conflict of interest to the outside lawyers, which is difficult to solve sometimes. Sometimes I think we should mediate the whole mediation scene. That would probably help, because we have so many different interests involved. And maybe also about what you said about the clause. Almost all of our cases we are found with us are based on clauses making reference to ADR or directly reference to mediation. And I do think that makes it easier for parties to go forward, that they don't have to decide on this once they have the dispute, but they are already obliged to do it by clause, and also that they don't have to go through an ad hoc procedure and face all possible procedural difficulties with an ad hoc procedure, but that they do have an institution and institutional rules behind that to govern the procedure. And maybe one last comment about the whole capacity building, and that we have to ensure that the lawyers know about mediation and can probably represent the parties in mediations. Just because so many academics are in this room, I think one step forward can be the ICC mediation competition, where we do educate the next generation of dispute resolution lawyers. So maybe all of those in academia, we can discuss that later on during the next coffee or via email, because it is the only international educational event for international mediation for students. So that is maybe one little step forward towards the future, where we have also lawyers pressing for mediation and not only parties.
Thank you. Laurence?
Thanks very much, Yas. Last week I saw my first coelacanth, a fish that's fascinated me since boyhood. It was thought to have been extinct for 70 million years until it was discovered off the southeast coast of Africa. Unfortunately, I wasn't at the depth of the coelacanth, about 120 meters below the ocean, when I saw it. It was on dry land and unfortunately wasn't alive. But it's referred to as old forelegs because the form of gills which it has, while not exactly operating as legs on the floor of the ocean, are widely regarded as the evolutionary predecessors of human limbs. although we only ended up with 2 and not 4 of the ambulatory appendages, we owe a debt of gratitude to our forelegs. Now, having shared this wonderful story, I have to link it to the theme today, which is a real challenge. But I suppose it is, how do we creatively involve our dispute resolution processes for investment disputes so that we do not one day resemble a fossil revered only by scientists? And I suppose in the context of a conference which has held dinner in a law library, creative thinking and the urge to search should be quite easy for us. I'd just like to make a kind of personal comment before going any further, just a reflection wearing mainly a mediator's cap, which I've worn for 21 years. And that is, and others have alluded to this, and I think that many of the objections or concerns raised about mediation in the context of investment disputes have a germ of legitimacy about them. And they are exactly the same kinds of concerns that were articulated, or at least that I heard in my world 15, 20 years ago. Issues that mediation has to be voluntary. In the world in which I live, that's a coelacanth argument. We don't even discuss that. Mediation is mandatory in numerous contexts. Issues that it has to be confidential. Around the world, there are many examples where mediation is very far from being confidential in any true sense of the word. It's difficult to mediate with state governments, yes, but I'm sure many others here have mediated with all 3 levels of government and have achieved satisfactory outcomes. Settlements have to be enforceable, yes, that's desirable, that's a typical legalistic approach, but there are different levels of enforceability, and so on. So I respect all of those arguments, and I think one of my themes is that we can look analogously from mediation developments in other parts of the world and all around us, and adapt and apply some of that experience and practice to the investment area. And I think there's an important framing issue here, and I know a number of people have touched upon this, but I just wanted to re-emphasize it. And the framing issue is that we don't postulate mediation only as an alternative to arbitration. And as many have already said, numerous arbitral disputes don't even get into the aegis of ICSID or UNCITRAL, and even when they do, they often don't go to hearing. So what we have to do is exactly what we've done at domestic jurisdictions, where we've said mediation in ADR is not only an alternative to court hearings, but it's an alternative to the way in which all those other disputes are managed short of a court hearing or an arbitration. And I would take issue with those who've said what happens out there in the process of settlement is necessarily ADR. I mean, I don't think just meandering through and reaching settlement is ADR. ADR has a structure and a set of objectives and a purpose and a value-adding intervener. And I'll argue in a minute that I think we need a lot of those structures. Let me just start with 2 stories from the developing world. The anticipation is that this year there will be $1 trillion in global FDI. Of that, the vast majority will go into the developed countries. And of course, we're familiar with the fall-off which occurred from the first quarter in 2008. The developing world had a slightly, and these are not equally scaled, by the way, but it had a slightly less dramatic fall-off. And one of the reasons is, of course, the abundance of resource. The resource sector is very strong in the developed world. And I'd like to come in the developing world. I'd like to come later, just very quickly to the point of needing to differentiate between different economic sectors in terms of dispute resolution methods. I think we need to bring that into the mix. So let me just touch on these 2 stories then. The first one is what I call remedial indigenization. This is in South Africa, where FDI is a very important requirement for economic growth. We're looking at 2.7% growth with 35% unemployment. I mean, it's hopelessly inadequate. At the same time, the government has a mandate which has been constitutionalized to promote what is called black economic empowerment. And it's done so in the mining industry by requiring all mining corporations, whether foreign controlled or domestic, to translate their what are called old order mining rights into new order mining rights, which give effect to BEE policies. Now, that has inevitably caught the attention of investors, and a case which is currently being managed under the additional facility rules of ICSID involve a very protracted dispute between an Italian investor and the South African government. And the argument of the South African government is, which incidentally is not a party to the ICSID treaty, but the argument is that there's enormous sensitivity over domestic policy in this area, and there's a concern that the arbitral tribunal will not be sensitive to this policy, which has a constitutional imperative behind it. And that other issues like the identity of the arbitrators, the costs, the likely remedies, and so on, are not going to be satisfactory. So there's a lot of backroom negotiation taking place without any formal kind of ADR. And so despite arbitration providing the so-called apolitical forum, the South African government's argument, for better or for worse, is that there is a highly sophisticated constitution, a very experienced constitutional court, and that it would prefer, were it possible, that domestic remedies should be exhausted before transposing it into this particular forum. So the second case study concerns Zimbabwe. Now here the land policies, and again we're not standing in judgment of these policies, but they are part of the domestic legal regime, and they've involved in extensive dispossession, including in this particular case by South African investors who own farmland. In the first case, the tension was caused by the plurality of different legal sources, international law versus domestic constitutional norms. In this case, the confusion was caused by the plurality of dispute resolution systems. So what has happened is that this claim by South African investors in Zimbabwe for dispossession of their farms has taken place in Zimbabwean courts, in South African courts, before the SADC Tribunal, which is the regional Southern African Development Council, before the South African Constitutional Court, and it is still going through those processes. And so, it's unlikely to reach finality for a considerable time to come. Interestingly enough, the RSA and Zim have just signed a bilateral agreement, quite an extensive one, and it makes future provision for ICSID, UNCITRAL or ICC arbitration. So it's in a sense maintained that particular vision, but it doesn't have any retrospective effect. It also includes within it, as an exception to the provisions of the treaty, all indigenization policies in both countries. So we have some real tensions emerging in the very kind of bowels of the tribunal. So what we have then is, I would argue, and it's nothing new, it's an incoherence, a fragmentation of sources of law and dispute resolution methods. And those have not, in these two cases, led to satisfactory outcomes. Now, if we start looking then at mediation options, and I was really tempted to make a very spirited defense of mediation in response to the spirited defense of arbitration. But to some extent, Wolf has done that already, so mine will be a slightly more moderated one. Obviously, one of the key tensions, I think, is not so much that we're dealing with governments, but that we're dealing with policy. I think that's one of the issues which detracts from the negotiability which we require in a mediation context. And that really is, I think, a fundamental difficulty. And in both these cases, we have it's either legislatively sanctioned policy or constitutionally sanctioned policy. And those are difficult to negotiate. However, the way in which policy is implemented and the consequences of its implementation are negotiable. So let's move then to this very elastic concept of mediation. And it does mean different things in different contexts. And I guess in my world, the key issue is it's joint self-determination. Mediation is about joint self-determination by the parties, but with a mediator, independent intervener, performing a value-added function in all sorts of ways. And I was really impressed by those who emphasised that the skills and techniques of the mediator, I think, are key factors in any successful mediation. Now, there are three traditional concerns, and I won't go into these other than mentioning them, that there are immense power problems in the context of investor-state arbitrations, that access to information is problematic, and that future business relations are not always going to be a possible basis of negotiability, particularly where there's an exit arrangement. And here we need to differentiate between different kinds of dispute. Where we're looking at an investment for diamonds under the soil or oil under the water, the investor is more likely to want to negotiate into the future. But where we're looking at a call centre involving business processing or agricultural land, as has happened in Zimbabwe, the investor can pick up and move to Zambia or Mozambique much more easily. So I think that factor of future business relations depends very much on the kind of dispute with which we're dealing. Just another point about the methodology of ADR. I think what it is so good at doing is saying, well, let's analyse the disputes. Let's disaggregate this dispute. There may be jurisdictional issues which need to go to an arbitral type process that cannot be resolved through other methods. But other aspects of the dispute, including compensation, might be much more mediated. So I think there's a lot of accumulated wisdom in the mediation world which helps us with this point. Let me get to what somebody earlier talked about, the need for something in there. I would just note the second point. I think the substantive redesign of investment agreements is upon us as the emerging world begins to flex its muscles. I think we're going to see much more insistence on true bilateralism in BITs, so that there are reciprocal rights and obligations, so that there are codes of conduct for corporations, so that eventually states will themselves become claimants under BITs before exit. I think that's going to take a while, but I do think that's going to be a valuable point in the future. So, let me jump forwards there, backwards. First of all, what should we do? I think we need to change our thinking. We need to loosen up our thinking and adopt the problem-solving method which mediation has gifted us with. I think we need to develop local and regional support structure. I mean, this has to exist. It's intellectual, it's legal, it's political, it's economic. Protocols for mediators, participants. There are many examples of this around. We can go to domestic dispute resolution, we go to international dispute resolution. Those protocols we can work with, UNCTAD and ICSID and so on, can develop those. Identification of skills and techniques has been touched on. Identification of mediators, and those could include organisations. They could include states. We can be very creative in our approach to this. Norms on conduct and behaviour for participation. I know this is problematic, but if you told litigants 20 years ago that in mediation they would be subject to norms of good faith and reasonableness and satisfactory mediation, they would have been shocked. Those are now part and parcel of the legal regulation of mediation in many jurisdictions. Timelines for completion, sanctions for inappropriate conduct in mediation. I know, again, that's very problematic, but references have been made today that there can be sanctions and rewards. In Slovenia, for example, a highly regulated legal profession, lawyers receive a 50% uplift in their fee if the matter is resolved through mediation rather than going to litigation. Arrangements for converting mediated settlements into arbitral awards. And I think this key thing, again, mediation methodology. Let's do pilot projects. Let's look short-term, intermediate-term, and long-term. Let's try some things and see how they work. Now, Susan's had a very busy time. I think we should give her 24 hours rest, and then I think she should start us drafting the Lexington Manifesto.
Are there any questions for Laurence before we questions from the bloggers for later on. I propose that we just hear in a row Jose Antonio and Noriyuki.
Good afternoon to everyone. The presentation that I have for you follows the following structure, but before entering into substance, I would like to make a couple of statements simply to share with you my general background and also my perspective. Now, I hate to say that I'm not an expert in mediation and I'm not an expert in conciliation. My background is basically public international law, ICSID, and the Colombian government. So whatever novelties or proposals I have for you will be taken from that background. The couple of statements that I have for you are first, arbitration per se, I don't think is negative, nor is it in itself dysfunctional, and in some cases it might be the last and most effective recourse. Second, I strongly believe that the system in itself is not in crisis, despite there being around 2000 a surge of international arbitration disputes, i.e. the Argentine cases and several others, mostly in Latin America. Third, in some of the institutional dispute resolution mechanisms, there have been many trials or pushes towards mediation or towards conciliation. I still recall there being a paragraph being introduced in the notification of registration when at ICSID, stating that even though the case was registered, the parties could still resort to arbitration. So those venues are still open. Having shared with you those general comments, which basically situate myself in the discussion, I have another news for you, which is we will start by the end. We will start by the third statement. Measures and actions derived from. We will start by measures and actions derived from model clauses on management and investment disputes. Those measures basically are the following, and the reason why I'm changing the structure is basically because I have heard many of these measures being outlined and shared with us all during the course of the presentation. The way, I with another colleague came about to these measures 2 years ago was I was heading the directorship of foreign investment in the trade ministry in Colombia right after coming from ICSID. And Colombia doesn't have still as many BITs or international investment agreements as the other Latin American countries, but I had the experience of being at ICSID and seeing countries like Argentina or like other countries being recipients of many arbitration claims. And it could indeed create a danger and a risk to the finances of the state if there were that many investor arbitration cases. So we basically put something that at the time we called, and the fellow that I'm talking about is David Pollack, we put together a list of ideals. First, having a designated lead agency. That agency that would indeed take care of the dispute and perhaps of the early resolution, not necessarily via arbitration, of those disputes. You have to know what is that agency in that particular country. Second, that agency would have many responsibilities. It would be the resource on investment treaty obligations. It would also be the lead agency providing support in investment treaty negotiations to the negotiating teams. And I think that a beautiful model is the Canadian model of negotiations. They have their negotiating team, which many are economists or policymakers, and they have a strong backup of their legal advisors. And it works in a very good manner. Record keeper of investors' state proceeding for use of policymakers and counsel in future claims. That speaks by itself. State contact for alleged aggrieved investors. Who does the investor talk to in the state when he feels that his rights have been breached? Facilitate early amicable settlement of disputes. Basically, that's where all the mediation and conciliation processes come into. And in case of claims, that agency would be in charge of leading the defense of the state, liaising with the outside counsel, if there is one, depending on the model, and liaising with experts and witnesses where appropriate. And something very similar to this, I believe, happens in Ecuador. There's a lead agency, the Procuración, and they also have their international council giving them some support. Those I would call part of the ideal measures. Also, there are other measures that we can call effective administration of investment obligations. What does that lead agency needs to have in order to have some effectiveness in its work? A key component that I believe in is that lead state agency should have some authority to collect evidence. Why? While being in government in Colombia, we had a case which never, hopefully, came or will come to investor-state arbitration, and an element was to collect the evidence. The lead agency that may be representing internationally the state may not necessarily have all the domestic tools to collect the evidence that will eventually allow it to either negotiate an agreement or defend the state appropriately. So those elements need to be in place. The other one might be a little bit controversial, but we need some regulation with some teeth, is that if that evidence is not provided to the specific agency, then there should be some consequences to lack of cooperation by other domestic agencies. Of course, there should be, under C, some procedures for interagency consultations between the lead agency, and that, I believe that it was either Jonathan or Mark who talked a little bit about this. Some procedures for interagency consultations when defending the state itself. That is a key component, because the arbitration defense team or negotiating team for the specific dispute may be very well versed in arbitration, but they may not be very well versed in telecommunications, which may be the subject matter of the dispute. So communication amongst the experts in-house is really important. There's another component which we framed as designation of contact persons for investment matters within the whole state framework. Those elements are also important, and I will wrap up that part by saying that that lead agency should have some budget of itself, either to conduct an arbitration or to conduct the whole mediation conciliation process. So those are the ideals. Those are what I would call the ideals, but those are elements that could work out within the framework of a state if the state so decides. And I believe that here we're speaking at a different forum. We're speaking at a forum where the question is, how can the system work in a better way? So now we're going back to the beginning, and there is an issue of the state being or not being able to implement those measures. How can we make those measures effective? And now I get to the concept of the treaties, the international investment treaty agreements being seen as self-executing agreements. Nobody tells the state within the treaty how to implement its obligations. So the idea behind this whole presentation is to pose a question as to, does it have to be that way? I don't think so. For instance, in free trade agreements, in trade law, there are many obligations which are not which couldn't be described as self-implemented. You need to regulate certain issues to comply with the treaty. For instance, decrease tariffs. That's one example that comes to mind. In the same sense, we could have certain clauses within the treaty, an international investment treaty, that fosters implementation of that agreement. And trying to be flexible, we have to have simply drafted a couple of statements. There's three alternatives that I would share with you. One, are sort of very intrusive into the sovereign competences of a binding commitment to implement international investment agreements by having, among others, various elements. One, a lead agency itself, which I have already explained. Another one, coordinating the state's actions and defense when faced by an investment treaty arbitration, and having the power to collect evidence. You can add to that also giving the power to the lead agency to actually negotiate a settlement with an investor. Is that regular or usual language that is included in international investment agreements? No. Can it be done? Yes, if the parties so consent. Because I know that this has never been done, and because it may create some questions, there's not only one binding, strong commitment to give the authority to this lead agency to negotiate agreements with disputing investors, but there's also a bit less strong suggestion, a commitment towards increasing the state's parties' ability to prevent investor-state disputes and the readiness in case of an investor-state arbitration. Basically, this is a deference option. You don't tell the state how to do it, but you say you have to do it. And a third option, which is the one that I like the least, but it's there for consumption, it's simply a soft law provision, which would basically record the both states' possibility of entering into an agreement where they actually agree that it would be desirable to have these implementation clauses. So those are the three options. I will simply finalize by saying that two things. First, there has been much discussion about why states cannot enter into an agreement when there's a dispute. Sometimes the authority doesn't exist. You have negotiators who can negotiate investment agreements on behalf of the state. You have the ministries But when you're faced with a particular issue, the actual individual who's representing the state of a particular ministry, say the Ministry of Telecommunications, even the ministry itself, may not have the authority and the capacity under the law to negotiate a deal with an investor. And it might be easier to wait 3 years down the line for an award. So those are the options, and thank you.
To save time, I would like to begin my presentation with yes. Thank you, yes, and it's my pleasure to be here before such distinguished people. Here, I would like to make my presentation from the viewpoint of the policymaker as well as the negotiator. But of course, this is my personal view. And as a last speaker of today's presentations, I would like to add a little bit different perspective to the discussion from the Japanese experience. That is not idea, but an approach to improve investor-state relations through communication mechanism among related parties. But before entering these details, I'd like to emphasize two things. First, this approach doesn't replace any kind of dispute resolution systems, especially binding arbitrations. Once problems are damaged and realized, we have to provide protection and remedies to the investors. As a negotiator of the investment chapter of Japan-Philippine EPA, which doesn't have the ISDS provisions, I strongly feel the importance and necessity of the strong system. Contrary. And second, also I'm introducing this approach as one of the ways to avoid and prevent disputes. In the context of this symposium, avoidance and prevention are not the main objective of this approach, but this is rather a consequence of this approach. Having said so, I'd like to begin with the analytic comparison between the two approaches. You can see the legal approach in the left of this presentation, and used in the IIAs and other international agreement. This legal approach consists of the binding obligation and enforcement mechanism to provide the remedies and facilitate compliance of the obligations. Now, on the other hand, the heart of the soft approach, I think, is the communication among the related party with the various style of the communication. And you may wonder into which category that ADR or mediation we discussed falls into, and I would like to leave this question open to everyone. And as for the scope, as you see that in legal approach, it is limited within the obligations stipulated under the agreement or arrangement. In soft approach, basically no limitation. And as for the effectiveness, even though you can discuss on the legitimacy or enforceability, as we discussed, still that legal approach has very, very strong implementation mechanism. On the other hand, as many pointed out, high cost is a headache. Also, although providing case laws, this legal approach, basically deal with the individual problems. In soft approach, there are certain merits, like saving costs, solving common problems for many investors, especially incorporating the opinions of SMEs. However, as you see, this approach relies on the voluntary actions of the host states, such that we face the question under what condition it will work. And here is my assumption how it works. That is through the confidence building. no one wants to be involved in dispute from the beginning. Both investors and the states may have perspective for either situations to contribute to or benefit from each other and achieve long-term relations and activities. And we think that regular and continuous dialogue between the investors and the host countries, supported by the home country, will help to create ideal win-win situation by building confidence among parties. And finally, this leads to the prevention, at least decrease in numbers and tensions of disputes. And such approach is not unique to Japan. I'm working in APEC as a convener of IEG, Investment Expert Group, and in its investment facilitation action plan, APEC economies agree the principle of building constructive stakeholder relations. In that sense, it is somehow the commonly understood principle. And now I would like to briefly explain Japanese experiences. Since we have much bigger outward investment than inward investment, we've negotiated and concluded the IIAs mainly with the developing countries as the home country of investment. However, Japanese private sector rarely use investment dispute settlement. There is only one case using IIA between third countries, but Japanese companies never use IIAs of Japan. And why? We don't know the exact reason. But we can think of the many hypotheses. First, maybe the relatively short history of negotiation IIAs. Japan is newcomer to the IIAs. Or maybe we can think about, I don't know if this is true or not, but maybe some point out the Japanese business culture to try to avoid lawsuits. Or maybe we can think about the type of the investments. Japanese companies have made huge investment in United States or Europe or in East Asia, mainly in manufacturing or retail or service sectors which require long-term presence, not only so-called one-shot type investment. So maybe we can think about those effects. Also, there are so many investors even in the same sector in the same country. For example, you can think of the many manufacturing sector in certain countries, and each companies may want to avoid to be seen as some kind of very apparent claimers compared with its competitors who keep silence. And also SMEs, there are so many SMEs investing abroad don't have the capacity to use ISDS. So I don't know exact reason, but maybe we can think of those elements. And so Japan has developed a mechanism of consultation in addition to ISDS for improvement of the business environment. Under which mechanism, investors have the opportunity to communicate and discuss any issues with the high-rank officers of the host country with the help of the home country. Here is the structure. I'm sorry, this is so small characters. This is the structure of this mechanism. You can see that first the host country will provide the so-called liaison office for the one-stop service for the complaint handling. And also the heart of this mechanism, so-called Committee on Improvement Business Environment. And here, this committee consists of the industry representatives, related agencies, host countries, and members of the embassy and government-affiliated bodies, and representatives from the home countries. And so here they will meet regularly. So here, sorry, also very small characters. Here, there are the examples of our experiences or cases with Mexico and Malaysia. And you can see that there are so many and a wide variety of the range of the issues we take now. You can see the improvement of public safety and the counterfeiting, implement tourism, implement customs and taxes procedure, infrastructure. In the case of Malaysia, improvement the quality of electricity, or the improvement of shortage of gas supply, and improvement public safety or anti-counterfeiting. So we can raise anything in the very wide variety of issues. And in general, that we got a very good reputation from both the host country and the investors. Host country welcomes because they can know investors and they can investors and their priorities, and they can show their efforts for the improvement of the business environment to the investors and get understanding of the investors. In other words, this mechanism fill the information gap and provide the transparency. Now, also, this is true for our investors. And in addition, for the investor, they can raise issues collectively and can create a good communication channel. However, I don't say this kind of mechanism always works. There are certain conditions or factors for success of such a mechanism. You can see those factors: structure, operation, maybe the involvement of hiring officers, or power of the coordinating agency, or choice of the issues. I'm prioritizing common interests. Also, you can think of the other factors. How those investors are influential in that country, or what kind of attitude the investor is taking, or what kind of the mutual relationship they are already establishing. And also, maybe the host country, home country can use development assistance as a leverage. But important thing is that under certain situation and well-crafted mechanism and the good intention of the parties, such mechanism works and prevent disputes. And now finally, I'd like to express my observation on the stage-by-stage approach. As stated before, we should use the good combination of tools through so-called program management spectrum. And in the peacetime period, this part, investors may have some kind of dissatisfaction or an expectation for improvement of investment climate in general. And in this stage, encouraging voluntary improvement of the host country and good behavior investor may be important. So you can establish the good confidence and mutual understanding. And once concrete problem or concern are raised at the early stage, prevention of escalation these concern to dispute is necessary. As we discussed, here communication can be the core of the action, and you may put ADRs in this context. Finally, sometimes you cannot avoid the concrete dispute raised. Here you should really rely on the arbitration or mediation to solve these disputes. So I think that I can add some kind of value to the discussion of the mediation ADR through my the Japanese experience. Thank you.
Because we want directly with Mariana's comments, and that will take the questions from the floor.
Okay, we have had a very long day, and this is the last one. So I'm going to be as brief as I can. I want to disclose where I'm coming from. I am the daughter of a judge, so I pretty much was raised in a race-based home. And I studied law for 5 years in Venezuela, practiced, and came to the U.S. and studied law again. And I have another 5 years of legal education here. And I'm actually now a law professor, and I teach ADR and mediation. So that is for a reason. And I'm going to try to explain to you why. There is a continuum. And one of the main concerns that I have after listening to all the presentations today is to move from arbitration as a panacea to now mediation as a panacea. The real issue is where the dispute fits in. depending on the needs of the parties, the specific circumstances, and the nature of the issue at stake. So, and the spectrum goes from, it starts with the notion of self-determination of the parties, and when complete delegated power to make the decisions to a third party. This third party could be public, which at the local level would be the state, and or could be private, which would be an arbiter. So when we are at the point where we delegated full power over process and over the outcome, we are in arbitration. In mediation, the parties are only delegating the power over the process, but not over the outcome. And that is a key distinction that we need to draw. So as one of the panelists in this last session was reminded us, it's a joint self-determination. And the main difference with settlement is that settlement is the result of compromising. So, and compromising is nothing but a power game, where the parties have to move to a middle, right? A happy middle, in the best case scenario. But if the power is not equally distributed, so the result is going of the settlement is going to replicate the power that the parties have. Mediation is not about that. Mediation is about moving from position-based that leads to settlement to value creation, in which the parties actually generate options based on their interest. And their interest is why they want what they want. There's a very simple example in the ADR field for those that are not familiar with it. And it's like opening or closing a window. So if you want the window open and the other party wants the window closed, if you settle and if you just compromise, the best case that you can actually have is half of the time open, half of the time closed, or like half open, right? So like a 50-50. But if you move to an interest base, then you go to like why you want it open and why the other person wants it closed. So you can start generating options that satisfy both parties. So party satisfaction is at the core of the mediation process. So for example, in the case of the window, open window, close, if you move to the interest, why the parties want what they want, you would have maybe that one wants it open because the person wants fresh air, and the other one wants it closed because the person doesn't want mosquitoes. So you could actually put a screen and give both what they want. Not every case is tailored for these, but that's why it was emphasized that you need experts in the ADR field leading the process, because there is a process, there is a lot of theory developed, and there are skills that require practice. So I want, with this, to move quickly, where is the mouse? To see how we need to start reframing the history of the development of conflict management or lack of conflict management till today. And the main theme pretty much from this last panel is that we need to move to a different paradigm, that moving from position-based to interest-based of the stakeholders. And the goal is to maximize joint gains through a participatory dispute and conflict management system. So our historical perspective in terms of conflict management or the lack of. So we start with force, power-based, the process is coercion, the results are imposed, the mechanism is dominance. In diplomacy, it's position-based, compromise, agreement, and enforced through political pressure. Arbitration, race-based. The process is adjudication. You have a third party that determines that one is right and the other one is wrong. You have an award and it's enforced. But when you have in dispute system design and conflict management design, those are interest-based. Mainly, obviously, there is you can resort at the end to rights-based if necessary. But the result are nearly self-enforcing agreements, because at the core of it is that an agreement should be better for the parties than no agreement. That is the rationale behind. So, but this all requires a complete shift of paradigm. It's not just about process. Process reflects the paradigm. Process reflects a set of values. And the shift of paradigm is from protecting investors' positions, investors' rights, to satisfying investor-state interest. I thought it was beautiful when our colleague from the Dominican Republic actually said, our countries and our investors. It's fascinating to move from I and you to we. Because what is really at stake is a relationship. It's a business relationship between the host states and the investors, in which we have actually a relationship of interdependence. So we need to move from protection to cooperation, from investors' positions to investor-state interest. And instead of having like a Bill of Rights, ideally we want to have a joint gains maximization, which is nothing but the process of value creation rather than compromising. So rather than having arbitration awards, we actually want what Jose Antonio Rivas actually suggested, committees of implementation at what Noriyuki from Japan actually suggested in terms of a consultation period in which we can actually like increase the level of communication and trust. And then after that, we need to be able to have a dispute system design and conflict management in place. So I would suggest that we can actually work this out based on what this panel has suggested within the current structure. How? There seems to be a gap between the BITs and the arbitration award. It cannot be that you actually sign an agreement and then the next time, like, you actually find each other in a procedure, right? In an adjudicated procedure. So the goal is to how do we work the gap in between? And the gap in between can be actually addressed through, with the goal of investor-state sustainable business relationship through maximization of joint gains, focusing on 3 strategic areas of development: the committees of implementation, dispute system design, and conflict management design. The goal of the committees of implementation should be consulting and monitoring. The dispute system design would be to resolve the specific disputes, and the conflict management system to manage the underlying issues, the underlying conflicts. So I actually would like to point here that the more, as Nancy Welch actually said before, the more we become a global community, relationships would matter more, because you are going to encounter each other over and over again. So we cannot see each transaction as an isolated fact. We need to start seeing the transactions between host countries and investors in a systemic way. So the goal of the committees of implementation would be to promote communication and cultural understanding to prevent the misunderstandings that Cathy was talking about before. The dispute system design would be to resolve the specific disputes, but tailoring it to the specific forum for resolution. And the conflict management system design would be tailored more to lead the conversation to address the underlying issues that have not developed yet to specific dispute. Okay, let me just quickly. Okay. One last point is that it's about the nature of the dispute between host countries and the investors. The host countries are actually have a public nature. That means that they have delegated power from the citizens. And in order to include the different stakeholders, there is in ADR a procedure called consensus building, in which there is a lot of experts, at least in the United States, where the different stakeholders are called to the table, and they actually reach agreements that are not based on unanimity, but rather they incorporate the interests of everyone at the table. And if someone disagrees with a specific aspect of it, the representative of the stakeholder has the responsibility to modify it. I just want to close with just pointing out that experience does not equal knowledge. So we need to be able to take every opportunity and analyze it in order to continue to grow, and not wait until a crisis develops in order to then try to fix the system.
We have about 15 minutes for questions and answers. Yes, sir.
My name is Jose Martinez. I'm with the American Development Bank. My question is for Mr. Kumberg. I'm also the litigator turning to an in-house counsel. And quite frankly, the most surprising finding when I started as an in-house counsel was the large number of people that was involved in the decision-making that were non-attorneys, and the large number of considerations that were non-legal in this decision-making process when dealing with distress aspects. So my question to you would be, how important do you think it will be in this process of promoting ADR to the people involved in this, to pay closer attention to the corporate processes that actually take place in the decision-making of whether or not going to arbitration, mediation, or any other alternative dispute resolution mechanism?
No, I think you make a very good point. I mean, we talked about how difficult it is within a state or state government to reach consensus and make decisions. But within a company, of course, and particularly large multinational companies, you have the same problem, and there are many different interests at work. And to actually reach a decision or a determination on how to process a particular dispute is often also quite cumbersome to deal with. And I agree with you, that is something that has to be taken into consideration when putting down or creating a mechanism to deal with this. Perhaps at the end of the day, though, the actual stakeholders within a company are probably can be dealt with in different ways than in a state itself, because they have political ramifications as well. And perhaps the actual process to reach a decision is easier within a company at the end of the day.
Thank you. Yes, sir.
And my question is for Antonio. How do you go about in the politicizing decision making, especially in legal agencies? The politicizing, especially in legal agencies, because in some countries there is a top-down approach. So the lead agency sometimes is not independent. Sometimes they could make a decision based on the interests of the country, but then when it goes to the politicians, they overrule whatever decision the agency makes. So how do you go about in creating a system where there's less of politics playing for the parties involved?
Thank you for the question. Politicizing of the lead agency's decisions. Oh, I have no different answer than saying that that lead agency must be comprised by highly technical individuals who know what a bilateral investment treaty is, what an investment chapter of a free trade agreement is, and hopefully that would have some exposure to investor-state disputes. that I believe is a key. I mean, there's many countries that have gone through the investor-state arbitration processes, and when I try to think in terms of investment models, VIT models, in my mind I no longer think in terms of those models of developing countries and those models of developed countries. I normally think more in terms of what states and what countries have actually gone through investor-state arbitration. And I like to see a trend. Those states that have gone through investor-state arbitration tend to have sort of more balanced approach, because they want to come halfway through regulation, allowing regulation, but also favoring investors whenever there has been a breach to their rights. So the people who are in the lead agency need to understand that. I mean, they're not only there to defend investors, but neither are they there only to defend the state. They are there ultimately to try to promote a solution that will be technically sound and will also be fair in whatever capacity they're acting. So I think training is a key element, and the proposal of those committees is that there be training. One last thing that I'll say before giving the floor to another question is there is actually a limited provision or some sort of provision that has already created a committee on investment. You can find it under Article 817 of the Canada-Colombia Free Trade Agreement. I mean, it's not as detailed as I have proposed here, but the guiding language reads as follows. The parties hereby establish a committee on investment comprising representatives of each state. The committee shall meet at such time as agreed by the parties and should work to promote cooperation and facilitate joint venture initiatives which may address issues such as capacity building to the extent resources are available, in legal expertise on investor-state dispute settlement, investment negotiations, and related advisory matters. So this is to say that there's already existing language and that if states take this issue seriously, they might bind themselves to creating mechanisms that allow for conversations before arbitration.
Can I start there? Yes. We have a question of Sylvia, Celine, and Ilawan, and Alvaro. Can we have all the questions at the same time? Yes, ma'am.
Just in listening, there's a practical matter that is a challenge for mediation, at least in countries like mine, like Colombia. And it's that investor-state conflict and disputes are very visible and politically very sensitive. And that makes mediation more difficult because the officer who actually decides on mediation has somehow a personal responsibility for having agreed to an agreement and has to almost justify the agreement more than possibly what you would find an arbitrator does, because not only does he or she have to legally explain it, but also politically explain it. And there, one of the areas that I feel that are maybe the weakest is that because there is a lack of consistency in arbitral awards in investor-state specifically, that's an area where they can't really rely on. So many times you have somebody who might be willing to come to an agreement because of the way that this case came out, but when you look at another case, the interpretation was different, so they can't really use that as a basis for coming to mediation and have to throw it into arbitration. So that's an area that kind of gets into something that's systemic, which is trying to come to consistency in the way that the agreements are interpreted, but that can have an impact on mediation and the countries need to be.
Celine?
Celine Nevet from the University of Ottawa. There's been a suggestion today a number of times about increasing the role of the home state in investor-state dispute settlement, the host state. And that's also in the UNCTAD report. And actually, when I first saw that, I was a little shocked. And I thought, we've come such a long way to depoliticize disputes. Are we really going to go back this way? And I thought, we should be open, maybe it has a role. And then I thought about what I know better. And after Chapter 11, and I thought, no, it wouldn't happen. But I thought, no, maybe, Canada's negotiating with China. Maybe in a different context it would be appropriate. But I would be interested in people who are suggesting this, the value they see and how it might work without undermining what we've achieved.
Thank you.
Yes, just 2 points. One point is on the implementing the home state involvement in the dispute. I think that can happen before it actually going to arbitration. I mean, before arbitration process starts, and then that can be an option that the party maybe have a talk. So it's like Mita was suggesting that just as committee in general that looking, monitoring the investment situation, not specifically on the case, but in general, and this might come up, during that regular consultation. So that's, I think, up to the point that the party decides to go to arbitration, that can be done. And later on, as I suggested this morning, it's just a forum, a formal forum for negotiation of settlement. And that can be just a place. But the role of the home state and host state at that stage is that not to intervene with the dispute itself, but to provide a formal forum so people can know that this is going on. The settlement is negotiating. It's not under the table, which is, it's very uncomfortable to do settlement in that way. Can I go to my questions? How are we going to, because there are suggestions that mediation or conciliation can happen along parallel to arbitration. I can see that in state and state dispute settlement process. But for this, whether it needs the cooperation from the arbitral tribunal as well, and whether arbitral tribunal is willing to suspend its proceeding pending the outcome of the mediation. That's happened in the court case, but I'm not so sure because now we are having contesting 2 forums, and I'm not so sure that without support from the arbitral tribunal it won't be possible. Again, as I see it, that ADR might be before actually things gets messy, and then it's like, husband and wife, you can still talk, but once there is a case, then probably very difficult.
Can I add, before we take Alvaro's question, can I add just one point by Ted, who says on Facebook, an interesting thing about Selin's remark and Vilawan is that it may be the host state rather than investor urging a more prominent role for the home state. So I want to keep that in mind as well when we discuss this.
Could I just weigh in on the last question? Because I think it's important.
Sorry, Cathy. Can we just go to Alvaro's question and be first?
Thank you very much. I'm sorry, Cathy. Thank you. I just want to be very careful with the statement that I'm going to make because I have here very learned and dear colleagues, other governments, and it's that we have to be very careful with what someone has suggested just a few minutes ago, with what was called the gun diplomacy. And I think we're in a different stage today. And we have to be very careful because we have very sophisticated companies around the world using the system in different matters to what was not created. And companies with a lot of power, this idea or premise that we have that these big, powerful countries putting pressure on companies. Sometimes it's the other way around. So I think we have to be careful and just to see how the system is working today. I think we have to make efforts to develop different ways to make the system work better. But as someone said before, I think we have moved many years forward. And I think it could be dangerous to go back to what we have gone over in many efforts.
Any more questions before we take the comments? Cathy, do you want to comment briefly?
No, I just wanted to be very clear that there are hybrid methods where you can do a mediation, arbitration, and RB. There's lots of ways to design a hybrid process. If that's your concern, part of it can be resolved through design issues. There may be other substantive law issues about it, but there are ways to do processes that allow you to mediate what you can and then arbitrate what you can't mediate. There are ways to do arbitration. It's called mediating against the envelope, where the arbitrator writes the award and then you mediate. If you don't resolve the dispute, the award gets opened. So there's a whole spectrum of possibilities when you get there that could be considered.
I want to emphasize one point which several people have already referred to, which is many theories can help improve the system, and we can pick mediation or conciliation or many alternatives. And I hate to be very skeptical, but not until some treaty incorporates that possibility, I believe it will be very difficult for an investor or a state to find himself or herself bound to go down that route. And I'll give you just one example. One example is the difference between the BITs under an OECD model and the difference between the NAFTA model, international investment agreements. Under one model, there's a notice of intent. Under the other model, there's no notice of intent. And yes, you can have questions about the benefits of the notice of intent under the NAFTA model, but it's so much better in terms of negotiations than having no notice of intent and just a letter saying, we have a dispute, we'll wait for you 6 months down the line and see you before the tribunal. So it's a key difference. If you have no treaty language encouraging that, I think it will be very difficult to make the system different.
Laurence?
Yeah, on Silva's question, visibility is an issue, and high visibility can be problematic. But again, I think we sometimes overstate these. I've certainly in Australia mediated in very high-profile native title claims with enormous degree of public interest and many levels of government and many agencies too. And in some sense, one sort of works through these things. One of the responses was touched on earlier, where we've got a very high-profile former Chief Justice in Australia who says to the parties, would it help when you go back to your constituents if I gave you a note signed by me which says I think this is a good settlement and you perform reasonably, and people clutch it to their bosoms and run off with it. On Celine's question, again I think we must start with the problem-solving methodology, and the question then is, who are the key parties who should be involved in dispute resolution? And that actually complicates it, because it's not only home states, but it's subnational authorities and the host states. It's the joint venture partner as well. It's the NGOs. And then we have to say, well, what level of participation should they have? Okay, should they be fully engaged so that their agreement is required for the final settlement? That's one extreme. Or should they just be given information as it proceeds? So there's a whole spectrum of levels of participation. So I think the problem-solving methodology, and sometimes I think we should really talk about this as mediation. We should say, why not do a problem-solving exercise before arbitration?
Thank you, Lars. Before we close the panel, Yes, go ahead, and I will have one little comment to make.
We should be creative and flexible when making the design. For example, in Japanese, in the negotiation, Japanese BITs, FTAs, first we have the difficulty because there are trading partners include such consultation mechanism. But once they understand the meaning of this mechanism, we can be very creative and flexible and cooperating with each other. So I think that we should have such model.
If I may finish the panel responding to the question around the home states and the intervention of the home state. In my experience, home states are much more comfortable intervening before the arbitration, sort of coming into play and having the case of the investor advanced to the other state because it's depoliticized at that stage and there's no problem. Now, is it efficient? In my experience, not always, because then the dispute continues. In other cases, and that's a paradox, in the arbitration, where it is already politicized, the state is more reluctant to intervene, but when it does, it's more effective. And I've been in cases where the home state would intervene to propose its interpretation of the treaty. And that's where you have a huge imbalance between the investor and the host state, where the investor does, by definition, does not know what the interpretation is. And the intervention of the home state, either after the arbitration or during the arbitration, can be effective. I'll stop with that. Susan?
Yes, we have another event that's coming in very shortly at 6 p.m. So actually, Anna, did you want to introduce Lucy Reed for a moment?